hear from Erica Olmstead. So Erica practices immigration, refugee, and criminal law. She has assisted individuals from all over the world to make applications to obtain status in Canada and to resolve complex issues of admissibility. She regularly appears before all divisions of the Immigration and Refugee Board and the Federal Court, and she has acted in cases before the British Columbia Court of Appeal, the Federal Court of Appeal, and the Supreme Court of Canada. Erica also works as a case review lawyer with the Legal Services Society Appeals Department, where she advises staff on immigration, refugee, and criminal law issues and works to support access to justice. She's an instructor with the University of British Columbia Certificate in Immigration, Law, Policies, and Procedures program, and is a regular presenter at immigration and refugee legal education conferences and events in British Columbia, and now in Nova Scotia. Come on up.
So on the conference agenda, it looks like my topic lists are quite varied, but they're actually all connected. So I've been tasked with taking you through the immigration admissibility process. How does it get triggered, and then what happens after that? And it's important to understand this process so that you know what options and what remedies are available to your client when they get charged or convicted with a crime. So I've started my PowerPoint with a quote from a case that was referenced by Les, where the United States Supreme Court calls deportation what it is. It's the equivalent to banishment or exile. And so individuals who are facing this severe consequence have the right to be informed of what those consequences are and what will happen if they're convicted of a crime. And as Les also mentioned, this line of thinking after this case became recognized in Canada through FAM, which is a decision by the Supreme Court of Canada that recognizes that immigration consequences have to be taken into account when they're sentencing an individual, and it's actually an error not to take immigration consequences into account. And then by Wong, which is a withdraw guilty plea case where somebody pled guilty and didn't know these immigration consequences would result. So how this process starts is that a Section 44 report is written. And that's really the triggering event. This is what that report looks like. And so if a client comes to you with a report that looks like this, and they say that this is the first time that they're hearing that they can be deported from Canada because of this conviction, that's when everything starts. That's when everything is triggered. If this is the first that they're hearing about it, then you should probably look into whether or not you do a conviction or sentence appeal, because they should have known before they got this report. And that's why this conference is being held today, so that everyone can assist in making sure people know this before they get this report. Just gonna go back in my slides a little bit, and I wanted to start by explaining a little bit about who does what, because I think the levels of knowledge in this room are a little bit different, and I don't want to take for granted that you know exactly who CBSA is and what CBSA does. Obviously, they're the people who take your passport when you come into Canada and who look at your passport, but they do a lot more than that. So they've got people who are like police officers who can go to your client's home and arrest your client. They've got hearings officers who are like Crown, and they go to proceedings and they argue these cases against people. They've got ministers' delegates who are officers who are managers with powers that are delegated by the Minister of Enforcement and Security and Emergency Preparedness, or the Minister of Citizenship and Immigration. And so they have special powers to do devastating things to your client. And then there's also removals officers who are tasked with removing a client from Canada. And hearings officers that can appear in different capacities. For example, they can appear before the Immigration Division, the Immigration Appeal Division, the Refugee Protection Division, or the Refugee Appeal Division. So these are all, when we talk about the Immigration and Refugee Board, these are the 4 divisions that you might appear in front of. Refugee Protection Division and Refugee Appeal Division are, of course, refugee specific, and the divisions that are more relevant to what we're talking about today is the Immigration Division, because they can issue removal orders and they can detain your client, or the Immigration Appeal Division, because if you can get there, then that's a great place for your client to be. They've got a lot of power. So it starts with the Section 44 report. This report, if for all the criminal practitioners, this is like the information in the immigration context. It sets out the basis that your client is inadmissible, and then provides a bit of particularized detail as to why they're inadmissible. And so this was talked about a little bit earlier today, but the inadmissibility provisions that your client might be inadmissible for are set out in sections 34 to 43 of the Immigration and Refugee Protection Act. So section 36 is the one about criminality that you're going to want to read and see exactly what it says, and we have a nice little summary of what that means that was handed out earlier. But unfortunately, there's a couple of other grounds that weren't covered very much this morning. They are more rare, and hopefully they don't happen, but they might. And so I guess one little side warning I have here is, and it's a little bit more out of everyone's control, but even if your client is acquitted of something, or the charges are stayed or not pressed, CBSA can still go after them under another ground. And we're seeing this with a client who allegedly shot a gun in a bar. I don't know why, but the Crown decided not to pursue it, pressing the charges, or taking them to court anyways. And so he's been written up for being a danger to the security of Canada for having committed that act. So that's something that criminal counsel don't have much control over. Obviously, if he was actually acquitted of the offense rather than the charges being stayed, that would have been better, because the Immigration Division is unlikely to go behind an acquittal. But I mean, I think there's not much control you have if the Crown is going to stay the charges to try to make them go forward with it and for there to be an acquittal. But just something to know that that's something that might happen, and if it's happening, you'll know because of this Section 44 report.
Question on that point.
Yeah.
I don't know if you would know this, but the Crown can withdraw a charge or even set it for trial and they can offer no evidence. Would an offering of no evidence be better than a withdrawal in terms of going behind?
That's a good question. I'm not sure. I mean, certainly what I can say is if whatever happened resulted in an acquittal, that would be better than the stay. In this case, I mean, I've seen one case like this in many years, and most cases resolved by way of a stay, and that's much better for most clients. So I just say that kind of as a caution that you might have done everything you could, and then there might be one more step for this client still. And so what happens when the Section 44 report is written is one of two things. A deportation order, if the report is found to be well-founded, will be referred to the Immigration Division in almost every case that's against a permanent resident, unless they're in breach of residency obligations, which you don't really need to know about today. And anything that's a little bit complex, if there's an issue and we need to figure out what the evidence says and whether or not it's established in the law, and there's even the slightest complexity, it tends to be decided by the Immigration Division. So the minister's delegate will refer that report to the Immigration Division to consider. But in some cases, that minister's delegate can also issue the removal order themselves. So the most common type of case that they can do this for is a in-Canada conviction against a foreign national. The idea being that the Canadian criminal court looked at all of this person doesn't have the same rights that attach to permanent residence, and so a minister's delegate can write the report, issue the removal order, and get them out of Canada pretty quickly. So if that person wasn't advised of the immigration consequences up front, there's a lot less time to fix it after that for a foreign national. Very briefly, there's three types of removal orders that can be issued. A deportation order is the one that comes with criminality. You'll get deported and then you will never be able to come back to Canada ever again without authorization to return. If it's a less serious breach, like you've overstayed your status, then you can get an exclusion order, which is for a 1-year banishment from Canada. After that, you can come back like anyone else, subject to rebuilding your trust in order to get a visitor visa in the first place, or a student permit, or a work permit. And this is more than you need to know, but if you've misrepresented, that comes with a 5-year exclusion order. So,
It's always fine.
for misrepresentation it is. It used to be 3, which is maybe where your memory is, but 2. It used to be 2, now it's 5.
Maybe 2, 3. That's all.
Yeah, they're more and more serious all the time. So can you stop this removal order from being issued if a Section 44 report has been written? You can, and there's limited discretion because the wording in the Immigration Act says that the CBSA may refer this report. This discretion is quite rare, but I wouldn't take this to give up. When I first started practicing, the precedents that I learned from involved maybe a 2-page submission from counsel with no evidence, trying to ask CBSA not to refer this an admissibility report. And with the new firm I'm at, and I've learned better now, we give packages of evidence with anywhere from 10 to 30 pages of submissions about why this person shouldn't be referred with. We get medical reports, we get psychological reports, we get counseling certificates and programming certificates, we get letters from friends and family, anything that you can imagine to show why this person should not be given a deportation order from Canada. And needless to say, we have a lot more success now than it used to when we were doing 2-page submissions.
I just have a question about even if you know, I mean, even if the crime is fairly serious, would you want to do that as a matter of best practice to put it in the record, like to
So that's when we find success now. It's changed because it was, I think it was 2013 when you've all heard about the right to the appeal division changing from 2 years to 6 months.
Yeah.
There's less rights. Now where we encounter most success is the cases where there is around a 2-year or 1-year sentence where CBSA knows there's nobody else who can forgive this
yeah,
person.
because of the immigration division.
Or
It's time.
exactly. So immigration division, you get the removal order, then you're out. So that's, I think, where we've started encountering more success is in the more serious cases. If it's someone with a long criminal record, then yeah, it's unlikely. But I mean, that's a good point about building the record. So that's what we really, whether or not they have immigration appeal division rights, this is where we try to get them on the track to wherever we're going with them. And I'll take you a little bit through that process, but ultimately what's going to happen is they'll have the right to go to the Immigration Appeal Division, or they'll have the right to file a humanitarian and compassionate application in most cases. But this is where you know something's happening and you can start building the evidence and building their case, and whatever happens, you can use that later. Some of the cases where we go to the Immigration Appeal Division, we're relying almost exclusively on evidence we got right away. So we've built the case up front, and then we can just build on it a little bit at the Immigration Appeal Division. So they do have limited discretion, and I do know that some counsel might just give up. So what I say our office does is particular to our office, but I think we've had success and we've seen success in doing that. Not everyone does it because you get refused a lot. And so I would prepare your client, if they're paying especially, about the chances of success on this. They're not that high. We almost always tell them you're likely to get referred, but there is a chance you won't. So the things that are most compelling in this type of case, though, is someone who has a single conviction, who had a problem and has identified what that problem is and taken steps to fix it. So if they have mental health issues and they're now on medication, or if they had, alcoholism and they've stopped drinking, if it was a financial crime and they found some stability in their life, and they can show CBSA, I did offend, but I'm not going to do it again, and here's why, then there's a possibility they won't get referred. So there are specific factors that are set out in these E&F, they're policy manuals that are posted online. So if you ever want to do these, go to those manuals, and they set out exactly what's set out here about the type of factors that the CBSA will consider. And so it's also, in particular for long-term permanent residents, that these are going to be successful. So somebody who's been here since they were a child or been here for 10 or 20 years, then there's a good chance that CBSA may not refer their case if they can show they're not at risk of reoffending. So if the report gets written and referred, which happens in most cases, it will go to the Immigration Division, who will decide whether or not this report is made out. And if it is, they have no power not to issue a removal order. So they have to issue a removal order if this person has this crime. They can't consider the fact that this person has 6 kids that they need to look after, the fact that they might not reoffend, none of that. They have to issue the removal order. And most of the cases they decide, I've got some statistics up here, are for serious criminality or criminality cases. And then there's not that many that are under the other grounds, but there are some. And as you'll see, that section 34 list is growing, so that maybe explains why that client who allegedly shot a gun, they're going after him, whereas we might not have seen cases like that so much before. So the Immigration Division is a tribunal. It's a court-like procedure. You appear in front of a person called a member, who's the judge. There's very informal rules of evidence. Hearsay is allowed, and the person concerned is a compellable witness, so they can be called upon to speak about their case. The standard of proof and onus of proof, we talked about that a little bit this morning. Burdens on the minister to prove the case, but they don't have to do much to prove it. And there are procedural fairness rights, though, which are some of the best way to maybe make a client's case for them. If a hearing is dragged on for 5 years, you might have an abusive process argument. If CBSA referred the report but never did anything with it and years have gone by, which happens because people go on maternity leave, don't go back, nobody picks up the workload. So we've actually seen quite a few cases where nobody did anything, and it's through the procedural fairness arguments that you can try to make arguments on their behalf. But they have a right to an interpreter, to an independent decision maker, the right to counsel if they can afford it, all of those good things. So the Immigration Appeal Division, we've talked all about it. This is the best place to be if you can get here. But as Les mentioned earlier, they've slowly been whittling away at who can actually get here. So it used to be everybody, and then it was people with sentences of less than 2 years, and then it was people with sentences of less than 6 months. And so I have a note up here about that really important distinction that the inadmissibility, the underlying one, is triggered for a sentence of 6 months. But to get access to the Immigration Appeal Division, you need that sentence of 6 months less a day. So our office does sentence appeals all the time to get that 1 day knocked off because people didn't know that was a threshold. That's really important. And we actually get consent of Crown a lot, and we don't even have to, and I'll talk more about this at the appeals panel tomorrow, but we get a surprising amount of leeway on extensions of time. So something to think about, and we'll learn more about tomorrow. But so people who don't have access are people with sentences of 6 months or more, and people with any inadmissibility under sections 34, 36, outside of Canada offenses, you don't get access. Even if you're a long-term Canadian permanent resident of 50 years, if you go down to the US and are charged with a crime or alleged to have done something there, you could lose your permanent residence in Canada and then not have a right of access to the Immigration Appeal Division. And so 34 is security, 37 is organized criminality, which is things like smuggling or money laundering, or being a member of an organized criminal group. And then you've got the violating international or human rights there. So one important deadline to note here is that you have 30 days to file the notice of appeal after you get that removal order from the Immigration Division. So if it's triggered, if you have access, you should make sure that your client files that. And the other thing is it's only permanent residents, permanent resident visa holders, and protected persons or conviction refugees who can access this division. Foreign nationals cannot go here. And so at the Immigration Appeal Division, there's a number of different procedures that can unfold. There's an early review, which is a paper-based procedure where you can do legal arguments about whether or not your client has access, for example. A number of the TRAN cases started to unfold that way, where people received conditional sentence orders that for quite a while were being interpreted as terms of imprisonment that barred access to the Immigration Appeal Division, until the Supreme Court of Canada found that interpretation of the law was unreasonable. Terms of imprisonment do not include conditional sentence orders, but we're still in that time period of all those people who lost access to appeal rights, so you might encounter those people, and that's what happened. Is for a while the court was saying they don't have access until the Supreme Court of Canada said they do. If you have a case like that, I'm happy to talk about it individually with you as to what remedies your client might have. There's also an informal dispute resolution, so if the case is sympathetic, you can write a letter asking for your client to have access to this, and CBSA can agree to put your client on a stay of their removal, so it's like immigration probation. And even if CBSA doesn't agree through alternative dispute resolution, or you don't have access to that, you can then go to a full hearing. And again, it's a tribunal where witnesses can be called to present evidence. The Minister's Counsel will cross-examine your client and ask them all about the horrible crimes they committed and what they've done to change their life and become a better person. And then at the end, you can give submissions and evidence to support the case. Often, if your client is a sympathetic witness, you can come to a joint recommendation with CBSA. Most of these cases end with a stay, so the immigration probation. That can be anywhere from, the appeal can be allowed outright if it's been a long time and they haven't reoffended. Often there's a stay of 1 to 2 or 3 years. I've seen one as high as 5 years, so there's no limit on how long the stay can be within reason. And so they can also allow the appeal on if there was a mistake in the law or in the facts, but the key thing here is the humanitarian and compassionate grounds. So the member can look at this case and decide if they have sympathy for it, and then decide to impose a stay or allow an appeal. So I've got a slide here that talks about what humanitarian and compassionate grounds are. You'll hear this term again more tomorrow because it's used in different contexts: to make an application, to be before the Immigration Appeal Division. And so it includes things like, how serious was this offense? What have they done to rehabilitate themselves? And again, rehabilitation is something that is so important. I find that it tends to win the day at these cases. So as criminal counsel, if you can start working with a client immediately on this, get them into programming, get them to acknowledge, if possible, if they can take responsibility for their crime and then show that they know where they went wrong and why what they did was wrong, they're much more likely to win this appeal. If clients go to the Immigration Appeal Division and are still trying to play the game they were playing in criminal court, where they say, I didn't do it, I just pleaded to get out of jail, or I didn't do it, there's this thing that had the witness lied, the Immigration Appeal Division will not accept that, and then it's going to be an uphill battle to win their case at all. And we see that quite a lot sometimes. So the earlier they can start to hear this, the more likely they might come around to accepting what they did and going forward with being able to present rehabilitation. So the amount of time they spent in Canada, their establishment, do they have children here? That's really important. What's in the best interest of those children? Do they have support from family and friends? And how much hardship would they face if they go back home? Those are what's considered by the IAD. And so, as I mentioned before, the IAD can stay a removal order, they can allow an appeal, or they can dismiss it. And as was mentioned this morning as well, if they get a stay, it will be automatically canceled if they get a new serious criminal conviction. And so sometimes a client doesn't even know if they're on a stay, and then it can be difficult, I think, for criminal counsel. But if they're talking about the fact that they had a hearing before, or they went through any sort of process, if you try to pull out pieces of information about what they've experienced before, and you think there's maybe even a chance they were before this hearing, this tribunal before, they might be on a stay, you can do an ATIP, you can write to the Immigration Appeal Division, and you can find this information out. So you can ATIP the Immigration and Refugee Board. And they're much quicker than RCMP or CBSA at getting that information back to you. So there's a bit of chart that you can use as a reference point later. I understand slides will be sent out about kind of access to the Immigration Appeal Division. And so the last thing to take this a different way is that around the Section 44 stage, the other thing that can happen is if there's a person who's making a refugee claim, CBSA can decide to suspend their refugee claim so that they don't go there at all. They can find them ineligible. And that happens if they're convicted of a serious criminal offense. And so the CBSA officer can write a letter and suspend the proceeding, and the proceeding will be terminated if they're even charged with an offense. Is that what this says? This process can be, I was talking with somebody earlier about how this is a little bit opaque as to whether or not they decide to do this. In some cases, when a person is inadmissible on the face, it will instead still proceed to the Refugee Protection Division, and then they can get excluded by the Refugee Protection Division. And it's kind of in CBSA's own mind whether or not they instead decide to go through the Immigration Division and the inadmissibility process. And so what happens with exclusion is that a person, the hearing on the merits won't be considered if there's an issue of exclusion. Normally this is dealt with first. I think the process has worked differently in the past where they'll hear it all together and make a decision. In BC at least, they always deal with exclusion first. And so a person can be excluded from refugee status if they've committed a serious non-political crime outside their country of refuge prior to his admission in that country of residence, or if they've committed a crime against peace, a war crime, a crime against humanity, or if they're guilty of acts contrary to the purposes and principles of the United Nations. So unfortunately, this process isn't quite as easy to define as inadmissibility. In inadmissibility, you know that 6-month threshold, you can learn it, you can memorize it, and you can predict the outcome. Exclusion is not that simple. The case of Feblis from the Supreme Court of Canada is a good one to read if you want to learn more about this exclusion topic. It says that 10-year or more possible sentence is a good yardstick for indicating whether or not a crime is serious, but it's rebuttable, so it's not a strict threshold in the same way that it is for inadmissibility. And again, it's also on that similar low threshold as reasonable grounds to believe, except they use the terminology serious reasons for considering. It doesn't depend on a charge or conviction, and so this is for offenses committed outside of Canada. And it doesn't matter if they've been completely rehabilitated and they committed this crime many, many years ago, they can still be excluded. And so when a person is excluded from refugee status, they then have access to the pre-removal risk assessment process instead. And I believe somebody else is talking about that process later or tomorrow? Tomorrow. Okay. And that's all. So I'm open to any questions. And I also in my slide have provided some resources because this is really just a high-level overview of some of these different processes, and there's a lot more information. These operational policy manuals, those are the best resource I find. They tell, CBSA uses them to figure out what they're supposed to do. And so
you can get in the mind.
Yeah, you can get in their mind and figure out where things are going. There's a great BC Law Society practice manual checklist about how to do an Immigration Appeal Division hearing. And it's really, really intricate. It's great. The IRB also has really good resources that you can turn to. And Les provided a really good what to do, what to look out for paper this morning. Peter from our office also has a good immigration consequences at sentencing paper that's detailed as well. So thank you all.
I have a
Oh,
clarification or question.
Which one, the departure or, so exclusion is the one I didn't really explain a departure order. That means you have 30 days to leave Canada. If you don't leave within those 30 days, then it becomes a deportation order and you can never come back without permission. A departure order, though, it happens when, I guess, for refugee claimants, if they lose their refugee claim, they're subject to that departure order, or permanent residents who haven't complied with their residency obligations.
And so then the exclusion orders are those that are more draconian and so the
Yeah, a little bit more serious.
permanency in terms of document.
Yeah, exactly, yeah. Yeah.
I was wondering, what are the timelines between you filing an appeal to the IAB and you actually doing a hearing? How it impacts strategy?
Good question. I mean, and I can tell you about the timeline for all of this. When a Section 44 report is ready, you can get to the immigration division pretty quickly. It really depends on the processing times. I've seen them scheduled as soon as like within a couple months. Or I have one that's been outstanding for more than a year and for some reason it's not getting scheduled and I'm just not touching it. And then from the immigration division, it's really quick to do that hearing. And then to get to the immigration appeal division, for a while I understand, and it's different across the country, but for a while I understand it was backlogs, long processing times, up to 2 years, but now I think they've said they've gotten it down to even as quick as 6 months, at least in the western region. So I know it's a little bit different. So I mean, I would anticipate from 6 months to a year. And then sometimes, so at the Immigration Appeal Division, you can get your decision then orally, or it can come in writing later, so that could also take a few months. And then if you want to appeal any one of those decisions, you can or judicially review them in federal court. You have a 15-day filing deadline, and then you go to federal court if you lose at any of those stages.
That was going to be my question, and I know that Benjamin Perriman is covering that tomorrow afternoon. I think that'll be our very last topic. But in terms, especially if you have presented it as a response to the procedural fairness letter, a lot of information, and then the Section 44 report is issued. Do you, as a firm, do you go to the federal court and do a JR of 44 report?
I think you probably see our firm name on most of the JRs for Section 44 reports. We do them a lot, but only for procedural fairness reasons usually. So substantively, it's hard to say that they did them wrong when they decide to refer them because they have so much discretion. And normally you're not going to win on that ground. But if they, I did one recently where they had all this evidence, so I ATIP'd them and I was trying to get whatever evidence they had for this criminal charge in the US, and they wouldn't give it to me. So they disclosed redacted ATIPs, and I said, we need to know the case that is to be met and to respond to it. And they wouldn't even give us a reason or a further extension after that to get that information. And so we judicially review on things like that are procedural fairness related.
And what about best interest of the child?
They just have so much discretion. We haven't done one successfully, at least, but I don't know that I've read a lot of cases. I mean, since Kantasamy, a Supreme Court of Canada case that was issued in 2015, kind of elevated how much you have to consider the best interests of the child. And so potentially if there is a lot of case law in humanitarian and compassionate application context where the officer is not alert, alive, and sensitive to the best interests of the child. They instead diminish the child's interests and kind of do half-hearted statements about why this won't be so bad for the child rather than acknowledging this would be devastating, but it's more important that we remove this criminal. So I see that there could be an opening to judicially review on best interests of the child if the officer really doesn't give it proper consideration.
My other question is about, so as you said, and as some of us know, the immigration division hearing is just a checklist. And there is no room for them to consider agency factors. But as a matter of practice, is that something that you want to at least put on the record in that context? Especially if you didn't have access to the immigration appeal division afterwards? Or does that make more numbers?
I used to, when I first started practicing, I used to put things on the record. I don't anymore because I've never had a circumstance where it made a difference later. Unless you're challenging something legally and then you plan to take it up to the federal court, then you would want to. Like if you're doing a charter argument, you would want to put that on the record. and give them the opportunity to decide it first. But if there's not going to be a legal argument or an argument proceeding in federal court, then I don't think it matters.
I had a hearing before the immigration division, and I intentionally slipped that through just so that it's on record that there were those issues, but the member clearly told me that she wasn't going to consider that because this is not a place for that. And I knew that I was probably missed on the place, but it's a really good argument. But this is the immigration division, and I cannot make agency arguments there. Still just kind of put it there, but she clearly said, Council, I'm not going to consider that. And so even if you put it there, it's just like a white hair. It is either this or that. So it won't, I don't know, you can put it there, but it's probably not.
And I mean, I wouldn't discount, I think there's room to chip away at the charter, and if this is really affecting the security of the person, and I mean, because as the immigration laws become more and more draconian and they take away more rights with less discretion, a lot of the broad interpretations were accepted on the understanding that there's these release valves, there's H&C, there's options for ministerial exemption applications, and these broad interpretations of the security provisions, for example. So I think there's room to chip away at the security of the person argument. And I know, for example, Audrey Macklin is doing a case with some other counsel. It's called Moretto, and it's in the Federal Court of Appeal, where they're trying to get the court to accept a broader interpretation of Section 15, Section 7 for a long-term permanent resident who has gone a long time without reoffending. And I think their stay was automatically canceled by virtue of a new serious criminal conviction. So keep an eye out for that case. But and yeah, you might have more comments on how to play around with the charter as they've been chipping away.
I was going to ask you about the principles and purposes of the United Nations provision, which I remember having been used long ago to sort of establish that drug trafficking was something that there were conventions about internationally. Therefore, the drug trafficking is contrary to the principles and purposes. And I'm wondering if since then, so it was 1985, if there's been any evolution of the use of that provision, you know, for trafficking in animals and parts or something, to expand the scope of exclusion.
I mean, I might pass that question along to anybody. I mean, I haven't seen much of it. I did kind of skip over that because I don't see it as much. I deal with inadmissibility a lot more. I don't know, what about your office? Do you?
No, I don't think we've ever had a 1FC something that couldn't be. But of course.
I mean, the one type of case, just for interest's sake, that we are seeing a lot of is mothers from Afghanistan who flee abusive relationships and then are alleged to have abducted their children, which is something that is insane that the government is expending policy resources on something like that.
Using the principles and purposes.
I don't know what section
Serious
they're going.
non-political crimes.
Yeah, serious non-political crime.
Kidnapping. Right.
Yes. Sorry.
Have you done if the conditions set for an IE stay is unreasonable in terms of like the client being able to access the service, let's say, a condition set to see a psychologist who speaks your language, but that's not available based on, you know, a healthcare system in crisis, this hospital, for example. So set by, you know, a judge where, you know, their process that might be available for the client, and then the person's expected to meet that condition, but
We've seen cases like that. Yeah, and normally it's something that we've dealt with on the reconsideration arguments. So another important point, and thanks for mentioning that, is at the end of a stay, it's not just done. There is a letter that's sent to your client where they have to say how they complied with the conditions, and then it's pretty automatic if they complied that the removal order gets set aside. But clients who move without updating their address because they think they're done could get the removal order upheld because they're not engaging with the process anymore. But so that's at the stage where we will explain this is why they didn't comply, they wanted to. I know that we've had one case that we're on the 4th or the 3rd judicial review and it's being sent back because the member has exactly that. They didn't comply with a counseling condition and then they were faulted for it and the federal court found, no, you have to actually engage with this and consider it. And I think CBSA won the last judicial review because they were upset about So that's a difficult question, and I think, I mean, what I would do is at the first instance try to not get that as part of the conditions, unless it's something that your client can meet.
Yeah, I support clients in conditions. I work on the second side.
Right.
Sometimes they're just impossible based on what's available here. Unless you can afford to pay, you know, a psychiatrist $3 an hour.
Yeah. Well, and in that case, I guess I would say go to whatever they can access.
Yeah.
If it's like a lot of universities, their psychologists, teacher or their centers, well, they'll be teaching new psychologists, and they've got discounted services. Get them to just go there a few times to show they tried their best. I think.
Cobble something together.
Yeah, it's going to be better than saying I just didn't do it. Yeah.
Jill's been designated representative for a client for maybe 7 years now, something like that. And
Oh, wow.
one of the only reasons that he's been able to meet any conditions at all is that support to some designated representatives. We haven't talked about too much, are so important. And so
Yeah. The moment I've got clients with a support person, that makes or breaks their case. Like people with even one person to support them and
Yeah.
help them through that side is so
Like the
important.
provincial context isn't taken into account sometimes.
Yeah.
Okay, that might be available in Quebec, it's not available in Nova Scotia.
Yeah, that's a good point. I think we've got a couple of questions if I have time.
Report that's generated to justify removal of the condition. Is that the police report that's in there, the crash sheet? Is it cut and paste, or is it actually the results of what happened in court? Because there can be a world of difference
Yeah.
between if there's a plea negotiation with a pre-statement facts.
So all you get is the Section 44 report itself, which sets out exactly and I think that's your question, is that they were convicted of trafficking over this amount. It was cocaine and maybe a couple other specifiers. To get the information about what happened, you're going to need to do some digging. So you're going to want to do ATIPs. CBSA will have a bunch of stuff, but they won't give it to you. So we always get extensions to provide further submissions based on access to those ATIPs. And often they'll give us 30 days, and then we say, you didn't meet your obligations under the Access to Information Act, give us 30 more. And then that's where we go to criminal lawyers and we ask them to help us get whatever they can. If there's an agreed statement of facts, we try to get that from them. And then we send it to CBSA ourselves to say, this is what was
So it's just bare bones.
Yeah, just like an information in the criminal context, yeah, very bare bones. And sometimes, there will be, when they write a referral report, they'll give a bit more and they'll set out the humanitarian and compassionate factors, and they'll set out some more information of whatever they've been able to gather. And then they have discretion on whether or not to refer that report. So
For
those are,
example, there could have been a very positive percentage.
exactly.
Nice comments by the judge and these things.
So that's for counsel to get and submit usually. CBSA, what they get, they'll get the police reports, they'll get the stuff that they know is gonna be inflammatory and bad usually. That's what I'll find in my access to information, or they'll get the reasons for sentence. I don't think I've ever, I'm sure they sometimes get the pre-sentence report, but it's always me providing it.
And if it's a conviction outside, then the council will have to get the law outside, get the conviction record, so you can then compare with Canadian law and make the argument that there's similarity and that kind of thing. So, we had a conversation outside, and I said I always feel that it is unfair on the part of, the applicant or the applicant or whatever, that you are gathering your own sort of information and disclosing it to, the minister's representative of the panel in order for you to be able to defend yourself. Whereas it's the opposite again now, a situation where the crown will have to disclose and
Yeah.
you have nothing to disclose to the crown pretty much.
Yeah.
Whereas in this case, you have to really let them know what's going on. So I don't know whether those circumstances one can go in and argue Section 7 or anything like that, considering that you are basically just developing that.
Yeah.
Their way of mind. I don't know.
Yeah, not an easy thing to decide, I think. The one good piece about that is you don't have an obligation to disclose the stuff that says really not the best things about your client.
Have you ever seen these proceedings start when someone is convicted but prior to sentence. So could there ever be a situation where you want your client to be sentenced on the same day and maybe not, or cultural assessment's going to take months and months because they're going to have that conviction on their record, and maybe at the end they're going to get a discharge, but really for a few months when their record is reviewed, it's going to say convicted.
I mean, I'd ask the other practitioners in here if they've seen that. I don't think I've seen one specifically. Every case, because they normally also refer to the sentence. But I mean, it's definitely possible. That's one thing is there's not a lot of information about how CBSA gets information about the charge and about the conviction. They have someone who does the digging and they find it out, but it's always at, can be at completely different times and.
Here it can take several months if you want to do a cultural assessment.
Yeah. I think normally they wait until after sentencing. I don't think I've ever seen a case before sentencing. All right, well, thank you all.